The email arrived at 11:47 p.m. on a Sunday, which should have been my first warning that something was catastrophically wrong. Nobody sends partnership dissolution notices on Sunday nights unless they're trying to catch you off guard. Subject: Urgent, Operational Restructuring Notice. From Marcus Chen, COO/CC. Jennifer Walsh, Legal Counsel. Dear Rachel, after careful consideration and review of our operational efficiency metrics, the board has determined that a restructuring of leadership roles is necessary to ensure continued growth and market competitiveness. Effective immediately, you are being transitioned from your role as Chief Product Officer to an advisory consultant position. Details regarding compensation and responsibilities are attached. We appreciate your contributions to VitaPath Analytics and look forward to your continued involvement in an advisory capacity. Marcus Chen, Chief Operating Officer, VitaPath Analytics. I read it 3 times, my coffee going cold in my hand, my brain trying to process what I was seeing. Advisory consultant position, transitioned, effective immediately. I'd founded VitaPath Analytics 6 years ago in my spare bedroom, built the core algorithm myself, brought on Marcus as COO when we secured our first major client, and grown the company to $8.4 million in annual revenue. I owned 51% of the company. I was the CEO, the technical architect, the vision behind every major product decision. You can't transition the majority shareholder and CEO to an advisory role. That's not how corporate structure works. That's not how anything works, unless they were planning something I hadn't seen coming. I opened the attachment with shaking hands. The document was dense with legalese, but certain phrases jumped out like red flags on fire. Restructured ownership agreement based on updated valuation, dilution of original equity positions, new board composition reflecting current operational contributions. Your revised ownership stake, 8%, 8%. They were claiming I now owned 8% of the company I'd founded, the company that existed because I'd written the original code, secured the initial funding, and worked 90-hour weeks for 3 years to build something from nothing. I pulled up our corporate documents, our operating agreement, our shareholder records, everything I could access from home on a Sunday night. And that's when I discovered the locked folders, files I'd created, systems I'd designed, suddenly requiring permissions I didn't have. They'd locked me out of my own company's digital infrastructure. At 41 years old, after 6 years of building a business that was supposed to secure my future and provide value to our clients, I was being systematically erased from my own creation. What I didn't know then, sitting in my home office with cold coffee and rising panic, was that Marcus Chen and Jennifer Walsh had been planning this for 8 months, that they'd been carefully documenting my absences, reframing my technical decisions as operational failures, and building a legal narrative that would paint me as a founder who'd outlived her usefulness. What they didn't know was that I'd been documenting everything too. Not because I suspected betrayal, but because I'm a data analyst who tracks metrics compulsively. Every email, every financial transaction, every client interaction, every piece of code written, all of it logged, categorized, and backed up to systems they didn't know existed. They were stealing my business. But I was going to track every penny, every lie, every fraudulent claim, and I was going to destroy them with the same precision I'd used to build the algorithms they were now trying to claim as their own. The war was just beginning. They'd fired the first shot with a Sunday night email. I was about to teach them what happens when you try to steal from someone who turns chaos into quantifiable data for a living. Monday morning, I arrived at the office at 6 a.m., 2 hours before anyone else. I needed to understand the scope of what I was dealing with before facing Marcus and Jennifer. My keycard still worked, small mercies, and I went directly to my office, or what used to be my office. My name was already off the door. The space had been cleared of my personal items, which were now in 3 cardboard boxes stacked near the desk. Pictures of my daughter Emma, awards from industry conferences, the whiteboard where I'd mapped out our product roadmap, all of it boxed up like I was already gone. They'd moved fast. Too fast for this to be a sudden decision. I ignored the boxes and logged into my computer. My admin access was gone, as I'd expected, but I'd built enough backdoors into our systems during development that I could still access critical information. Not to sabotage, just to document. I pulled up our financial records for the past 9 months and started downloading everything to an encrypted external drive. Revenue reports, expense allocations, contractor payments, board meeting minutes. Then I accessed our code repository and pulled commit logs, showing who had written what code and when. Finally, I accessed our client communications database and downloaded every email thread involving product development. By 7:30 a.m., I had 847 gigabytes of data safely stored on 3 separate drives, backed up to an encrypted cloud service Marcus and Jennifer didn't know existed. Rachel. Marcus's voice from the doorway made me jump. He was early, too, dressed in the expensive suits he'd started wearing once we hit our first $1 million in revenue. I see you got my email. Your email claiming you're demoting the majority shareholder and CEO? Yes, I got it. I kept my voice level, professional. Gave him nothing to use against me later. Want to explain how you think that's legal? It's all in the documentation. The board determined. What board, Marcus? We have 3 board members. You, me, and Jennifer. I never voted on this. Jennifer's vote and yours don't override my majority stake. Your stake has been diluted based on the new funding round and updated valuations. What new funding round? I'm the CEO. I would know about new investment. He smiled, and I saw the calculation behind it. Actually, you were increasingly absent from operational decisions over the past 6 months. The investment came through channels you weren't directly involved with. Your ownership was diluted accordingly based on the participation terms. Show me the documents. Jennifer will provide everything you need to review. In the meantime, I need you to return your access credentials and company property. The transition needs to be clean. I stood, picked up my bag. I'm keeping my laptop. It's company property, but so is the work I've done on it. I'll return it after I've extracted my personal files. Rachel, don't make this difficult. Difficult would be calling a lawyer right now. Difficult would be freezing company accounts I still have signature authority on. Difficult would be informing our 3 largest clients that their contracts were negotiated under false pretenses. If there's been a material change in company ownership they weren't notified about. I met his eyes. I'm being extremely cooperative, Marcus. I'm walking out quietly while I figure out exactly how you think you're pulling this off. That's the easiest version of this you're going to get. I walked past him, my external drives safely in my bag, my laptop under my arm. I didn't take the boxed personal items. Let them think I was beaten enough to abandon my own things. In the parking lot, I sat in my car and finally let myself shake. Adrenaline and rage and something that felt like betrayal but sharper, more personal. I'd brought Marcus into this company. I'd trusted him with operations while I focused on product development. I'd made him wealthy, and he was stealing everything I'd built. My phone buzzed. A text from Jennifer Walsh, our general counsel. Can we talk? Coffee? I'm trying to help navigate this smoothly. I almost laughed. Jennifer, who'd been copied on that Sunday night email. Jennifer, who apparently voted with Marcus to dilute my ownership. Jennifer, who was now offering to help me navigate my own corporate execution. I texted back, no thanks, talk to my attorney. Then I called the one lawyer I knew who specialized in corporate theft. Samantha Rodriguez had helped a colleague through a similar nightmare 3 years ago. If anyone could unpack this mess, it would be her. Rodriguez Law, the receptionist answered. I need to speak with Samantha Rodriguez. Tell her it's Rachel Morrison from VitaPath Analytics, and someone is trying to steal my company. Samantha's office was downtown, all glass and steel, and the kind of expensive minimalism that suggested her cases usually involved sums that made my $8.4 million in revenue look quaint. But she took corporate theft cases pro bono sometimes, especially when they involved women founders getting forced out of their own companies. Walk me through it, she said, after I'd explained the basic situation. Start from when you first noticed something was wrong. I pulled out my laptop and the external drives. That's the thing. I didn't notice anything was wrong until Sunday night. But when I started reviewing the data I'd been collecting, I saw the pattern. I pulled up a spreadsheet I'd created during my sleepless Sunday night. 6 months ago, Marcus started scheduling board meetings during times I'd already blocked off for my daughter's medical appointments. Emma has a chronic condition that requires regular treatment. He knew my schedule, but suddenly every critical operational meeting was scheduled during those blocks. Did you attend? I rescheduled some appointments, missed others, but yes, I was absent from approximately 40% of board meetings over the past 6 months. I pulled up another file. Here's where it gets interesting. The meetings I missed? Those were the ones where they apparently discussed new funding rounds, ownership restructuring, and my operational performance issues. Samantha's eyebrow rose. They documented your absences. Extensively. But what they didn't document is why I was absent, what I communicated about rescheduling, and the fact that every meeting I missed, Marcus had specifically scheduled during block time. I showed her my calendar exports with the pattern highlighted. It's systematic. He created absences he could point to later. What else? I pulled up financial records. 3 months ago, we signed a contract with Meridian Health Systems. $2.3 million, our largest deal ever. I negotiated it, I pitched it, I designed the custom algorithms they needed. But in the contract documentation, Marcus is listed as primary contact and lead negotiator. Did you review the contract before signing? I reviewed the technical specifications and pricing. Jennifer handles contracts. I trusted her to document the business terms correctly. I pulled up emails. But look at this. I have email threads proving I was the one negotiating terms, communicating with their technical team, making promises about product capabilities. Yet somehow in the final contract, I'm not mentioned. They're erasing your contributions. Systematically. I opened another folder. Financial allocations. Over the past 6 months, Marcus has been categorizing his salary and bonuses under product development costs, while categorizing mine under administrative overhead. Makes it look like he's the revenue generator and I'm administrative deadweight. Samantha was taking notes now, her expression shifting from curious to focused. What about the code? You said you're the technical architect. Every line of our core algorithm I wrote. I have commit logs, version control history, dated documentation. But 3 months ago, Marcus hired 2 contractors, both former colleagues of his from his previous company. They've been contributing to the code base, and their commits are being highlighted in board presentations as evidence of new technical leadership. While your contributions are what? Minimized, categorized as maintenance rather than development, made invisible. I pulled up one more file. And here's the piece that should terrify them. I track everything. Every email, every decision, every financial transaction. I have 847 gigabytes of company records documenting 6 years of operations, including the past 8 months of systematic preparation for forcing me out. Samantha sat back, a small smile playing at her lips. You're a data analyst who documented your own corporate coup. I'm a data analyst who documents everything as a matter of professional habit. They just happened to stage a coup while I was logging their every move. Can they argue you illegally accessed company records? I'm still the CEO and majority shareholder until a court says otherwise. I have every legal right to company records, and I access them using systems I built and credentials I legitimately possess. I met her eyes. I didn't hack anything. I just used the infrastructure I created before they thought to lock me out completely. Smart. She pulled out a legal pad. Here's what I need from you. Categorize that 847 gigabytes into evidence categories. Financial misrepresentation, IP theft, breach of fiduciary duty, ownership fraud. Create a timeline showing when each action happened and what documentation proves it. Can you do that? I can have it done by Thursday. Make it Wednesday. We're filing an emergency injunction to prevent them from making any material changes to company operations or ownership structure until a judge can review the documentation. She stood. Rachel, I'm going to be straight with you. This is going to be expensive, emotionally exhausting, and there's no guarantee we win. Corporate theft cases are hard to prove because so much depends on intent and paper trails. But if you have what you say you have, I have it. Every penny, every email, every lie, all documented with timestamps and source verification. Then we're going to make them regret they ever tried to steal your company. The next 72 hours were the most intense work I'd done since founding VitaPath. I turned my dining room into a war room, covering the table with printouts and timelines and categorized evidence folders. Emma, my 15-year-old daughter, helped organize files when she wasn't at school or treatment. "Mom," she said Wednesday afternoon, "I'm sorry this is happening because of my appointments." I looked up from the spreadsheet I was building. "What?" "Marcus scheduled meetings during my treatment times to make you look absent. This is my fault." "Emma, no." I moved to sit beside her. "This is Marcus's fault for being a manipulative criminal. You, have a medical condition that requires treatment. There's nothing wrong with me prioritizing your health. What's wrong is him weaponizing that priority against me. But if I didn't need so much treatment, then he would have found another excuse. Predators look for vulnerabilities. Yours isn't a flaw, it's just a circumstance. His exploitation of it is the flaw." I pulled her into a hug. "You're helping me build the case that's going to destroy him. That's the opposite of being at fault." She helped me create a visual timeline that evening, color-coding different types of evidence. By Wednesday at 11 p.m., I had everything Samantha needed. Financial fraud in red, IP theft in blue, fiduciary duty violations in green, ownership manipulation in purple. The timeline looked like a rainbow of corporate betrayal. Samantha filed the emergency injunction Thursday morning. By Thursday afternoon, Marcus and Jennifer had been served with papers requiring them to appear in court and explain why they shouldn't be prevented from making any changes to VitaPath's operations or ownership structure. Marcus called me 17 times that day. I didn't answer. Let him wonder what evidence I had. Let him panic. Jennifer sent an email. "Rachel, this is getting out of hand. We can settle this reasonably without expensive litigation. Please call me." I forwarded it to Samantha with a note. "They're scared." Her response, "Good. They should be." The preliminary hearing was scheduled for the following Tuesday. 5 days to wait while I wondered if Marcus and Jennifer were destroying evidence, preparing counter-narratives, or simply planning their next move. I spent those 5 days doing what I do best, analyzing data and finding patterns. I discovered that the new funding round Marcus mentioned had come from a shell company Jennifer had set up 3 months earlier. The company had no employees, no revenue, no apparent business purpose, other than investing exactly enough money into VitaPath to dilute my ownership from 51% to 8%. Under the terms, Marcus and Jennifer had apparently approved during meetings I'd been systematically excluded from. I discovered that the 2 contractors Marcus hired weren't just his former colleagues. They were being paid through a consulting firm he'd established, meaning he was essentially paying himself for their services while categorizing it as external development costs. I discovered that our largest client, Meridian Health Systems, had been told I was stepping back from operations due to family health issues, and that Marcus would be their primary contact going forward. This was news to me since I'd spoken with their technical team 3 weeks ago about feature enhancements. Every discovery went into the evidence files. Every lie, every manipulation, every fraudulent claim. Documented, time-stamped, cross-referenced with supporting data. By Monday night, I had a 247-page brief documenting systematic corporate theft, not accusations or theories, hard data showing exactly how Marcus and Jennifer had attempted to steal my company. Samantha called after reviewing it. "This is the most thorough documentation I've ever seen in a corporate case. They're going to settle." "I don't want a settlement. Rachel, I want them prosecuted. I want them barred from serving as officers in any corporation. I want them to lose their professional reputations the way they tried to destroy mine." My voice was steady, cold. "They didn't just try to steal money. They tried to erase 6 years of my work, my technical contributions, my role as founder. They used my daughter's medical condition as a weapon against me. I want consequences. Consequences mean going to trial. Months of depositions, legal fees, public scrutiny. Your company operations will be paralyzed. My company operations are already paralyzed. Marcus is driving it into the ground while pretending to be its savior. At least a trial puts everything on pause and gives me a chance to reclaim control before he destroys what I built. There was a long pause. Okay, we go to trial. But Rachel, you need to understand what you're signing up for. They're going to attack your competence, your mental state, your parenting, everything. Corporate litigation gets ugly. Let it get ugly. I have truth and data on my side. What do they have? Expensive lawyers and a willingness to lie. Then we'll see which matters more in court. The preliminary hearing was in Judge Patricia Morrison's courtroom. No relation, though the shared last name felt like a weird cosmic joke. The judge had a reputation for being detail-oriented and intolerant of corporate shenanigans, perfect for a case built entirely on documented evidence. Marcus arrived with 3 attorneys, all from the kind of firm that bills $800 an hour. Jennifer had 2 more lawyers flanking her. They looked confident, prepared, ready to dismiss my claims as the desperate flailing of a founder who couldn't handle operational growth. Samantha and I sat at our table with boxes of evidence and a projector for presenting data. I'd created visual presentations for every major claim. Hard to dismiss documented fraud when it's displayed on a screen with timestamps and source citations. Judge Morrison called the hearing to order. This is a preliminary hearing on an emergency injunction request. Ms. Rodriguez, you're claiming that Ms. Morrison, the plaintiff Ms. Morrison, has been fraudulently removed from her position as CEO and majority shareholder of VitaPath Analytics. That's a serious allegation. What evidence do you have? Samantha stood. Your Honor, we have 247 pages of documented evidence showing systematic corporate theft. With your permission, I'd like to walk through the key findings. Proceed. For the next 40 minutes, Samantha presented our case. She showed the pattern of meetings scheduled during my daughter's medical appointments. She showed financial records proving Marcus had been reclassifying costs to minimize my contributions and maximize his. She showed the shell company Jennifer created solely to dilute my ownership. She showed email chains proving I'd negotiated our largest contracts while Marcus took credit. Most devastatingly, she showed the code commit logs. Visual graphs showing that I'd written 78% of our core algorithm, while Marcus had contributed exactly 0 lines of code, but was claiming to be the technical leader. Marcus's lead attorney, a man named Richard Thornton, stood when Samantha finished. Your Honor, this is a classic case of a founder who can't handle the evolution from startup to mature business. Ms. Morrison is a brilliant coder but a poor manager. The board made difficult but necessary decisions to ensure VitaPath's continued growth. Mr. Thornton, Judge Morrison interrupted. I'm looking at documentation showing that your client scheduled board meetings during times he knew Ms. Morrison would be unavailable due to her daughter's medical appointments, then used her absences to justify removing her from operational decisions. How is that proper corporate governance? Ms. Morrison could have rescheduled those appointments or attended remotely. Her daughter has a chronic medical condition requiring regular treatment. Are you seriously arguing that a board member should deprioritize their child's health care to attend meetings that could have been scheduled at literally any other time? Thornton shifted uncomfortably. The pattern of absences suggested Ms. Morrison was disengaged from company operations. The pattern of absences suggests Mr. Chen was deliberately creating situations to manufacture evidence of disengagement. The judge flipped through documents. I'm also looking at this shell company created by Ms. Walsh for the sole apparent purpose of diluting Ms. Morrison's ownership. Want to explain the legitimate business purpose of that structure? Jennifer's attorney stood. Your Honor, the investment was necessary for operational expansion. The investment came from a company with no employees, no revenue, and no business operations beyond this single transaction. That's not investment. That's manipulation of ownership structure. Judge Morrison set down her papers. Here's my preliminary ruling. VitaPath Analytics is frozen. No operational changes, no ownership transfers, no material decisions without court approval until we can fully adjudicate this case. Ms. Morrison is reinstated as CEO effective immediately with full access to company systems and records. Mr. Chen and Ms. Walsh are suspended from operational authority pending investigation. Your Honor, that's extreme, Thornton began. What's extreme is attempting to steal a company from its founder using her daughter's medical condition as a weapon. What's extreme is creating fraudulent ownership structures to dilute legitimate equity stakes. What's extreme is claiming technical leadership while having written exactly 0 lines of code. The judge's voice was ice. This case is going to trial. Discovery begins immediately, and I'm warning all parties. I do not tolerate fraud in my courtroom. If I find that any evidence has been destroyed or testimony has been fabricated, I will rule accordingly. She banged her gavel. This hearing is adjourned. Trial date is set for 8 weeks from today. Walking out of that courthouse, I felt something I hadn't felt in 2 weeks. Hope, not naive optimism, but the solid satisfaction of watching documented truth get recognition. They're going to settle now, Samantha said in the parking lot. Morrison just signaled she sees through their bullshit. They'll want to avoid trial. I'm still not settling. Rachel, they tried to destroy me. I want them destroyed right back. Legally, thoroughly, publicly. I looked at her. How much do I owe you so far? About $45,000 in fees and costs. I felt my stomach drop. That's a lot. It's going to be more if we go to trial. Probably $200,000 total, maybe more. Corporate litigation is expensive. I thought about my savings, about what I could liquidate, about whether destroying Marcus and Jennifer was worth bankrupting myself in the process. Then I thought about that Sunday night email, about walking into my office to find my name already removed, about them using Emma's medical needs as a weapon, about 6 years of work being systematically erased. Do it. File for trial. I'll find the money. I can work on contingency. No, this isn't about money. This is about principle. I'll pay your fees because I want you fighting for me, not for a percentage of damages. I pulled out my phone. I'm going to liquidate some investments, take out a loan if I need to, whatever it costs. Samantha studied me. You're sure? I've never been more sure of anything. They bet I'd be too scared or too broke to fight back. They were wrong. Discovery was a nightmare, but a productive one. Depositions revealed that Marcus and Jennifer had discussed the Rachel problem for 8 months before taking action. Email chains showed they'd explicitly planned to use my daughter's medical appointments as justification for excluding me from decisions. The most damaging discovery came from Jennifer's personal email account, which we subpoenaed. Messages to Marcus discussing how to minimize Rachel's technical contributions in documentation and establish alternative leadership narrative before she notices the pattern. They'd planned this, methodically, deliberately, and they'd been stupid enough to document their planning in writing. Marcus's deposition was particularly satisfying. He'd spent years telling people he was the operational genius who made my technical vision commercially viable. Under oath, confronted with email evidence and code commit logs, he had to admit he'd contributed minimal technical work and had primarily focused on sales and client management. So when you told Meridian Health Systems you were the technical architect of the platform, Samantha asked, that was false. It was simplified. It was a lie, wasn't it, Mr. Chen? It was marketing language. Marketing language that claimed credit for code you didn't write, algorithms you didn't design, and technical decisions you didn't make. I was representing the company's capabilities. By claiming personal capabilities you don't possess. Yes or no, Mr. Chen? Did you write the core algorithm that VitaPath's platform is built on? No, but did you design the data processing architecture? No, but Did you create the user interface, the reporting systems, or the predictive modeling features? No. So when you told clients and investors that you were the technical leader, you were lying. His attorney objected, but the damage was done. Marcus had admitted under oath that his claims of technical leadership were fabricated. Jennifer's deposition revealed the shell company details. Under questioning, she admitted the investment vehicle had been created specifically to dilute my ownership stake and had no other business purpose. So you created a fake company to fake an investment, to fake a reason to dilute Ms. Morrison's ownership, Samantha asked. It was a legitimate corporate restructuring. Using a shell entity you controlled, during meetings you deliberately scheduled when Ms. Morrison couldn't attend, to achieve an outcome that benefited you and Mr. Chen while harming the founder and majority shareholder. That's an oversimplification. It's fraud, Ms. Walsh. You created a fraudulent investment to steal someone's company. Yes or no? Did you disclose to Ms. Morrison that you were creating this shell company before you used it to dilute her ownership? The board approved. The board you and Mr. Chen controlled after excluding Ms. Morrison from meetings? That board. Yes or no, Ms. Walsh? Did you tell Rachel Morrison you were creating a company specifically to dilute her ownership before you did it? No. Because you knew she'd object. Because it was an operational decision. Because you were committing fraud and didn't want to get caught. By the time depositions concluded, we had everything we needed. Admissions of fabricated credentials, evidence of deliberately scheduled exclusion, documentation of shell company fraud, proof of IP theft through false attribution. Marcus and Jennifer's attorneys requested a settlement conference. The settlement conference was held in a neutral attorney's office with a mediator present. Marcus and Jennifer arrived looking diminished, their expensive lawyers suddenly less confident. The mediator laid out the situation. Given the evidence that's been disclosed, I think we all recognize that a trial would likely result in a verdict favoring Ms. Morrison. The question is whether we can reach a reasonable settlement that avoids the time and expense of litigation. Marcus's attorney spoke first. We're prepared to offer Ms. Morrison full restoration of her CEO position and original equity stake in exchange for her agreement not to pursue criminal charges or civil damages beyond attorney fees. I looked at Samantha, who nodded slightly. That was the opening offer. We could negotiate from there, but I wasn't interested in negotiating. No, I said. Everyone turned to look at me. Rachel, Samantha said carefully, maybe we should hear the full proposal. No, I don't want settlement. I want trial. Ms. Morrison, the mediator began. I understand you're angry, but settlement would give you everything you've asked for. Full control of your company, your ownership stake restored. It doesn't give me what I actually want, I interrupted. It doesn't give me public acknowledgement of what they did. It doesn't create consequences that prevent them from doing this to someone else. It doesn't hold them accountable beyond just giving back what they stole. You'd be made whole. I can never be made whole. They used my daughter's medical condition as a weapon. They systematically erased 6 years of my technical contributions. They lied to clients, to investors, to anyone who would listen about who built this company. I looked directly at Marcus. You tried to steal my life's work because you thought I was weak enough to let you. You were wrong. And I want a jury to say you were wrong. I want it in public record that you're a thief and a liar. Rachel, Marcus said. The first time he'd spoken directly to me in weeks. I'm sorry. I made terrible decisions. I was wrong. Can't we move past this? You're sorry you got caught. You're sorry the documentation you didn't know I had is destroying your defense. But you're not sorry you tried to steal my company. You're just sorry you failed. I stood. Samantha, we're done here. See you in court. I walked out, leaving the mediator sputtering and Marcus looking genuinely shaken. In the parking lot, Samantha caught up with me. That was either the bravest or stupidest thing you could have done. Which do you think it was? Brave, expensive, but brave, she smiled. We go to trial in 3 weeks. Let's make sure we win. The trial lasted 2 weeks. Samantha presented our evidence methodically, building a case that even the most skeptical juror couldn't dismiss. Financial records showing systematic misattribution of revenue. Code commit logs proving my technical contributions. Email chains documenting the planned exclusion and ownership manipulation. Calendar data showing the pattern of meetings scheduled during my daughter's medical appointments. I testified for 6 hours over 2 days. Walked the jury through building VitaPath from nothing. Explained the technical architecture I'd created. Detailed the client relationships I'd built. Showed them what it meant to have 6 years of work systematically erased by people I'd trusted. Marcus's attorneys tried to paint me as an absentee founder who couldn't handle operational scaling. But our evidence of deliberate scheduling conflicts destroyed that narrative. Hard to claim someone's absent when you have proof the meetings were specifically scheduled when they couldn't attend. Jennifer's attorneys tried to claim the shell company investment was legitimate corporate finance. But when Samantha showed the jury that the company had been created solely to dilute my ownership, had no other business purpose, and had been structured specifically to avoid my knowledge or consent, that narrative collapsed too. The most powerful moment came when Emma testified. At 15, she was poised and clear as she described her medical condition and treatment schedule. Then Samantha asked her a simple question. Did you ever tell your mother you didn't want her attending your medical appointments? No. She offered to miss some so she could attend Mr. Chen's meetings. But I told her I needed her there. The treatments are scary. I wanted my mom. And did your mother ever miss your treatments for those meetings? She rescheduled some appointments when she could. But when she couldn't reschedule, she always chose me, because that's what good mothers do. Watching Marcus's attorneys try to cross-examine my 15-year-old daughter about her medical needs, while she calmly explained that my presence at her treatments was necessary, that moment, I think, is when we won. The jury deliberated for 4 hours. When they returned, the forewoman read the verdict. On the count of breach of fiduciary duty, we find in favor of the plaintiff, Rachel Morrison. On the count of fraudulent ownership manipulation, we find in favor of the plaintiff, Rachel Morrison. On the count of IP theft through false attribution, we find in favor of the plaintiff, Rachel Morrison. 8 counts total, 8 verdicts in my favor. The damages, $4.2 million in compensatory damages for the harm done to my ownership stake, professional reputation, and business operations. An additional $2.8 million in punitive damages, because the jury found Marcus and Jennifer's actions to be particularly egregious, plus full attorney fees and costs. Total, $7.3 million, including my legal fees. But more importantly, a public court record establishing exactly what they'd done. Documented fraud, documented theft, documented manipulation of a founder using her daughter's medical needs as a weapon. Judge Morrison added her own ruling. Marcus Chen and Jennifer Walsh were barred from serving as officers or directors of any corporation for 7 years. Their professional reputations didn't just take a hit. They were functionally destroyed. 18 months after that Sunday night email, VitaPath Analytics is thriving. I'm fully back as CEO with an expanded technical team who actually write code instead of just claiming credit for it. We've brought on new clients, developed new features, and grown revenue to $11.2 million annually. Marcus and Jennifer both settled the civil judgments by transferring their ownership stakes in VitaPath to me. I now own 94% of the company I founded, and agreeing to payment plans for the remaining damages. Neither could find employment in tech after the trial publicity. Last I heard, Marcus was working in retail management. Jennifer was trying to rebuild her legal career doing contract document review. I don't feel sorry for them. Play stupid games, win stupid prizes. They gambled that I'd be too scared, too broke, or too broken to fight back. They lost. Emma's medical condition is stable. She's thriving as a junior in high school, considering studying computer science in college. She wants to be a data analyst like her mom. Because, she told me recently, tracking information is power, and I want to have power. Smart kid. I speak at conferences now about corporate theft and founder protection. My advice is always the same. Document everything. Track every penny, every decision, every contribution. You might never need the evidence, but if someone tries to steal what you've built, you'll be glad you have it. The lawsuit cost me $187,000 in legal fees before I won reimbursement. It cost me 2 years of stress, sleepless nights, and anxiety about whether I'd lose everything I'd built. It cost me relationships with people who thought I should have just settled quietly, but it gained me something invaluable. Proof that truth and documentation can beat fraud and manipulation. Proof that careful record-keeping is a weapon against predators. Proof that sometimes the right thing to do is the hard thing, even when settlement would be easier. Marcus and Jennifer tried to steal my business by erasing my contributions, weaponizing my daughter's medical needs, and systematically excluding me from my own company. They did it deliberately, methodically, with planning and malice. I tracked every penny they stole, every lie they told, every fraudulent claim they made. I documented it with the same precision I used to build the algorithms they tried to claim as their own. Then I destroyed them in court. Not with anger or emotion or personal attacks, with data, with evidence, with 847 gigabytes of documented truth that they couldn't lie their way around. They thought they were stealing from a technical founder who wouldn't know how to fight back. They were wrong. They were stealing from a data analyst who turns chaos into quantifiable evidence for a living. That Sunday night email tried to erase me. Instead, it triggered the most thorough documentation of corporate theft I've ever compiled. Every penny tracked, every lie exposed, every theft quantified and proven. The jury believed the data. The judge ruled accordingly. Justice was served with timestamps and source citations. And now, VitaPath Analytics belongs to me again. Not because I was given it back as a settlement. Because I proved in court with irrefutable evidence that it was mine all along. They stole my business. I tracked every penny. I won in court. And I'd do it again without hesitation, because some things are worth fighting for. Your life's work, your reputation, your technical contributions, your daughter's well-being. The documentation saved me. The data won the case. The truth prevailed. That's what happens when you try to steal from someone who treats documentation like a religion and data like a weapon. You lose, publicly, completely, with consequences. Document everything, track every penny, trust the data. It might save your business someday too. If this story resonated with you, please like and subscribe. Share your experiences with business partnerships, corporate betrayal, or legal battles in the comments below. Remember, documentation is protection and data is power. Until next time.